TORRE Napahiya at sinampal nag-ebidensya ni Atty.TORREON Napahiya sa National TV, hindi na makapagsalita pa. Matapos tawaging fugitive si Pastor Quiboly, sinupal pa na naman ni Atty.TORREON si TORRE, kung saan sinabi niya na mali ang kanyang sinabi na fugitive nga ang kanyang kliyente na itong si Pastor Quiboly. Ayon pa nga kay Atty.TORREON, attorney or lawyer ng QOGC at siya ring abogado ni Pastor Quiboly, ayon sa kanya, hindi mo pwedeng tawaging fugitive ang aking kliyente hanggat hindi pa siya nahatulan sa korte. Wala kang karapatan o yung mga pulis na tawaging fugitive si Pastor Quiboly dahil unang-una hindi pa siya nahatulan kahit isang kaso dito sa korte. Kayang maling-mali ang ginagawa nyo. At hindi lang yun, marami pang reklamo laban dito kay TORRE kasama ang mga pulis na si TORRE nga ang namumuno. Ayon pa dito kay Atty.TORREON, apat na sektor ng QOGC ang nilosob daw ning mga tauhan ni TORRE. Walang search warrant at walang warrant of arrest. Basta-basta na lang daw sila lumusob doon sa apat na sektor ng simbahan ng QOGC kung saan nga ay nagbigay ng trauma at takot sa mga tao doon. Ayon pa nga kay Atty.TORREON, hindi maganda yung ginawa nitong si TORRE at ang kanyang mga pulis dahil nagkaroon nga ng hindi magandang komunyon doon, lalong-lalo na doon sa mga tao na nagsisimba at nananalangin na bigla-bigla na lang silang nilosob doon at yung mga pulis daw ay nakatagi pa ang muka at kahit na nga i-interviewin sila ng social media ay hindi daw nagsasalita. At meron pa nga daw silang dinitain na mga kasapi ng QOGC na wala namang ginawang masama. Ayon pa nga daw dito sa kanila, sa mga pulis daw ay sinabi na nanlaban daw, pero ayon dito sa isang kasapi ng QOGC na yung bulo o yung itak na dala-dala ng mga nagsasamba doon ay pagkatapos na nila magsamba ay gagapas daw sila ng mga damo doon at yun ang nakita nila, pero yun nga ay pinusasan at dinala sa kulungan. Kaya narito guys, panoorin natin.
Suggest, Mr. Chair, if it's possible to call for Mr. Quiboly to surrender to the jurisdiction of the court of Pasig Regional Trial Court, because until then he's just a fugitive of the law, fleeing, hiding behind his members and followers, and whom we in Region 11 will continue to pursue and look for him, to arrest him and bring him to the jurisdiction of the court, whether he like it or not. We don't like this, but this is ordered by the court, and it is our duty, Mr. Chair. Thank you very much, sir.
Sir, quick reportation.
Thank you, General TORRE. Yes, go ahead.
I would just like to comment, Your Honor, concerning these opinions of two generals already, which I think need to be properly corrected, Your Honor. If a person has a warrant of arrest, Your Honor, the subject of the warrant of arrest has two options. Either he submits himself to the jurisdiction of the court, or he questions the finding of probable cause, Your Honor, which Senator Lacson did, okay? And if the DOJ would not side with him, he can go on certiorari to the Court of Appeals without ever surrendering. Santiago case would prove that. So, a person, even if he has a warrant of arrest, can choose to exhaust all of these remedies, Your Honor, such as but not limited to questioning the finding of probable cause. So I do hope General TORRE would disabuse his mind that the only option of a person who has a warrant of arrest is to surrender, Your Honor, because he has a right, Your Honor, to insist that there is no probable cause, especially in this case, that the cases were dismissed already by the City Prosecution's Office, Your Honor, a long time ago. And the complainant in this case filed a petition for review 4 years ago, Your Honor, and this was not acted upon by the Department of Justice, and this was only acted upon when it became fashionable to attack Pastor Apollo Quiboly, when there was already a Senate investigation being instigated by Senator Hontiveros. All of a sudden, voila, there is already a resolution on the petition for review. We did not file it, it was the complainant. We filed a motion for reconsideration, Your Honor, a long time ago. Until now, there is no resolution as to it. And then, a few days thereafter, that there was a resolution, we have a warrant of arrest. So as a lawyer, Your Honor, I filed motions, Your Honor, so that the warrant of arrest, as well as the information, can be invalidated by the court. That is a remedy provided for by the rules of court. So therefore, General Torre cannot dictate upon Pastor Apollo Quiboly as to what to do. So therefore, for the police authorities to always say that my client is a fugitive, excuse me, under what legal?
He is one with you, one with the community of Tamo, especially the members of the Kingdom of Jesus Christ, in their search for justice and peace, Your Honor. But on these matters, on the innocence or guilt of Mr. Quiboly, his lawyers here and representatives know that the wheels of justice will start only upon his submission to the jurisdiction of the court, to which his 5 other companions had already done last March 2024 by posting bail on the cases that were filed against them, and corresponding warrants were issued.
Iba pa ito sa yung sinasabi nyo na at large na 5?
Yes, sir.
Iba pa yung
No, sir. There were 6 of them. 5 of them, there were 6 of them, and all of them were charged in Davao and in Pasig. In March 2024, a Davao court issued warrants of arrest for 6 of them. 5 of them posted bail, except for Mr. Quiboly. Until now, his warrant on Davao is still standing. And all of them are also charged in Pasig.
The same 6?
Same 6 are charged in Pasig. And none of them posted bail because there's no bail recommended for the 6 of them. We have captured one, Pauline Canada, and she is still in the custody of the CIDG. So as I'm saying, Your Honor, the wheels of justice can only start if he submits to the jurisdiction of the court, because everything that we discuss here, saying that whether he is innocent or guilty, are of the moment, because we are not the court that will stress out all those issues. So I would really suggest, Your Honor, that Mr. Quiboly submit himself to the jurisdiction of the court, because sooner or later the law will catch up with him, just like what happened to Pauline Canada. She did not surrender. We hunted her down, looked for her, and we arrested her and brought her to the judge who ordered her arrest. And until now, she is still in our custody, in CIDG in particular. So I would suggest that Mr. Quiboly to end all of this and spare all his followers and believers of all these things, of this they perceived harassment, which are actually not harassment but are just part and parcel of the implementation of the warrant of arrest against him. So I would suggest, Mr. Chair, if it's possible, to call for Mr. Quiboly to surrender to the jurisdiction of the court, of Pasig Regional Trial Court, because until then he's just a fugitive of the law, fleeing, hiding behind his members and followers, and whom we in Region 11 will continue to pursue and look for him, to arrest him and bring him to the jurisdiction of the court, whether he like it or not. We don't like this, but this is ordered by the court, and it is our duty, Mr. Chair. Thank you very much, sir.
Sir, quick
Thank
repartation.
you, General Torre. Yes, go ahead.
I would just like to comment, Your Honor, concerning these opinions of 2 generals already, which I think need to be properly corrected, Your Honor. If a person has a warrant of arrest, Your Honor, the subject of the warrant of arrest has 2 options. Either he submits himself to the jurisdiction of the court, or he questions the finding of probable cause, Your Honor, which Senator Lacson did. Okay? And if the DOJ would not side with him, he can go on certiorari to the Court of Appeals without ever surrendering. Santiago case would prove that. So a person, even if he has a warrant of arrest, can choose to exhaust all of these remedies, Your Honor, such as but not limited to questioning the finding of probable cause. So I do hope General Torre would disabuse his mind that the only option of a person who has a warrant of arrest is to surrender, Your Honor, because he has a right, Your Honor, to insist that there is no probable cause, especially in this case, that the cases were dismissed already by the City Prosecution's Office, Your Honor, a long time ago. And the complainant in this case filed a petition for review 4 years ago, Your Honor, and this was not acted upon by the Department of Justice, and this was only acted upon when it became fashionable to attack Pastor Apollo Quiboly, when there was already a Senate investigation being instigated by Senator Hontiveros. All of a sudden, voila, there is already a resolution on the petition for review. We did not file it, it was the complainant. We filed a motion for reconsideration, Your Honor, a long time ago. Until now, there is no resolution as to it. And then a few days thereafter, that there was a resolution, we have a warrant of arrest. So as a lawyer, Your Honor, I filed motions, Your Honor, so that the warrant of arrest as well as the information can be invalidated by the court. That is a remedy provided for by the rules of court. So therefore, General Torre cannot dictate upon Pastor Apollo Quiboly as to what to do. Several instances in the past, such as perhaps former Senator Honasan, I do hope he will forgive me, Ocampo, Senator Ocampo also did that in the past, Your Honor, by questioning the finding of probable cause. If these were available to those persons, why not to Pastor Apollo Quiboly? They are always describing my client as a fugitive. What is your legal basis? The last basis, Your Honor, is Republic Act 11983, passed only on March 11 of 2024. What is the definition, legal definition of a fugitive under the present dispensation, Your Honor? According to Section 3G, those who flee under the following circumstances after conviction by a Philippine court to avoid prosecution. That is our prevailing law. So therefore, for the police authorities to always say that my client is a fugitive, excuse me, under what legal basis? Even if you use, Your Honor, U.S. court decision and even Black's law definition, Your Honor, it provides a fugitive from justice is a person who, having committed a crime, flees from the jurisdiction of the court where the crime was committed, or departs from his usual place of abode and conceal himself within the district. That is Black's law definition. If we will use likewise Supreme Court decision Rodriguez versus Comelec, Labaw versus Comelec, it includes those who after conviction flees to avoid punishment, but also those who after being accused flee to avoid prosecution. So we are still questioning the after being accused. So for the PNP to always claim that my client is a fugitive, under what legal basis? Can you please cite to us, just because he has a warrant of arrest? And can you rightfully say that he has knowledge of that warrant of arrest? Did you present evidence? In Labaw versus Comelec, Your Honor, the Supreme Court, he was a candidate for mayor. There was even a warrant of arrest. And they even tried to arrest him in a church, Your Honor. Yet the Supreme Court did not consider him as a fugitive from justice. What would be the basis of the PNP? Require Pastor Apollo Quiboly to surrender? And require us to surrender him? What right do I have to require my client? I'm just a lawyer, Your Honor, a glorified agent of my client. I cannot tell my client to surrender. That is not within my power. If I do that, I might be disbarred, Your Honor. So I do hope and pray that the PNP should likewise perhaps do more research in accusing certain persons as a fugitive, or that require the lawyer to surrender him or his members. We do not have that power. An accused has the right to also insist to avail all of his remedies provided for under the rules of court. And Pastor Apollo Quiboly is precisely doing that.